Good morning, my ladies and my lords. My name is Muoki. I hold brief for Mr. Kanjama. I was requesting for directions in petition of appeal application numbers E17 of 2021. It's a notice of motion application. My name is Muoki. I hold brief for Mr. Kanjama. I was requesting for directions in notice of motion application number E017 of 2021, filed on 1st of October 2021.
An application on what, please?
My lady, the application was for consolidation and waiver of the requirement to supply physical copies of the record of appeal.
So the directions we've given or the ruling on consolidation doesn't capture that?
It does not capture that, my lord.
The ruling on consolidation has already been given. The petitions are all consolidated.
Very well, my lady. I stand guided.
Yes.
Honorable Chief Justice, I have confirmed the Deputy Registrar. That application was never filed. It was submitted but returned by Mr. Kanjama, if I'm not wrong. It was not on the record.
I stand guided.
Confirmed, Mr. Kanjama. It's not on the record.
Very well.
Sir.
My Lady, the Chief Justice, my lords and my ladies, may I humbly request that 40. This will go a long way to reducing the time that all of us will spend in the oral submissions. That is my humble request. So, sorry, my lady, the Chief Justice,
yes.
I was requesting that the number of pages be increased from 15 to
40 pages. Yes, you will allow us to adjourn for only 10 minutes so that we consult and come back on the ruling on those issues.
If it may please the court, my name is 𝙏𝙗𝙧 𝗏𝙗𝙧. I appear for the Attorney General, and in that capacity, I hold brief for Mr. Kennedy Ogeto. And although your leadership said one representative for each of the parties, your leadership, I would like to draw your attention that I'm appearing here together with Mr. Kamau Karori and Mr. Paul Nyamode in petition number 16 of 2021. Thank you.
Good morning, my ladies and my lords. My name is Gumbo. I am privileged in this matter to be led by learned senior counsel, Professor 𝙏𝙗𝙖𝙣. He is not with us this morning, he is indisposed. Together with my other colleagues, Mr. Moses Kipkogei, 𝙠 𝙔𝙘𝘀, Mr. Justice Munyidhia, who is following the proceedings online, Mr. Ken Meli, Mr. Ronald Makoha, and Ms. Wambui Muigai. We appear for the Independent Electoral and Boundaries Commission in petition number 13 of 2021. Thank you.
Next is Excellency Uhuru Muigai Kenyatta.
Please, the court. My name is Kiragu Kimani. I appear with Mr. Paul Wanga in the Attorney General's petition E016. My client is a 22nd respondent. In the petition by Mr. Morara Omoke, that's number 15 of 2021, my client is a first respondent. And finally, in petition number 18 of 2021, my client by the Independent Electoral Boundaries Commission, my client is a 79th respondent.
Thank you. There are other parties. David 𝙏𝙗𝙧
May it please you, my lady, the Chief Justice, my ladies and my lords, my name is Nelson Harvey. I appear for the first to fifth respondents in all the appeals and the applications. These are Dr. David 𝙏𝙗𝙧, James Gondi, Wanjiru Gikonyo, and 𝚋𝚋 Angelei. Thank you.
Let please the court.
I appear with Ms. Muthoni Nyuguto for the 11th.
Your name, please?
My name is Martha Karua, appearing with Muthoni.
It's for record purposes. We need to record.
I'm leading Muthoni Nyuguto for the 11th, 12th, and 13th respondents in the Attorney General's appeal, that is petition number 18 of 2021.
Thank you.
And like my learned senior, 𝙏𝙗𝙧 𝙁𝙤𝙧, although the directions are for one council, it's difficult for those of us who are leading to come without the advocate on record.
Okay. Thank you.
The Honorable Chief Justice, my lords and ladies, my name is Elias Mutuma. I appear for the 7th, 8th, and 9th respondents in the Attorney General's petition, alongside Ms. Caroline Gerono and Professor 𝗡𝗄𝘀𝗀𝗧 𝗡𝗲𝘄𝑀, who is appearing online. Thank you.
Put on your mic, please, so that we can record.
Honorable the Chief Justice, the Deputy Chief Justice, and judges of the Supreme Court, my name is 𝙏𝙗𝙧 𝗔𝙗𝙀. I appear alongside Morara Omoke and Lesingo Topua. We appear for the appellant in petition number 11, that is Morara Omoke, who is also the 13th respondent in the Attorney General's petition, and he is the 76th respondent in the petition by IEBC. Thank you.
This may it please you, the Lady Chief Justice, my lords, my ladies. I appear, my name is Paul Mwangi, I appear with Mr. Jackson Awele in petition number 11, Morara Omoke, for the 4th respondent, for the 2nd respondent and 4th respondent. In petition number 16, Attorney General's appeal, we appear for the 20th and 23rd respondents. And in petition number 18 of IEBC, we appear for the 17th and the 77th respondent. Thank you.
My Lady, the Chief Justice, my name is 𝙏𝙗𝙧 𝗏𝙗𝙧. I'm privileged to appear before you one more time, this time for Dr. Jack Mwimali, the 14th respondent in the IEBC appeal, and he's number 74 in Omoke's appeal. I hold brief too for Ms. Kituku, who appears for Muhuri, the 78th respondent in Omoke's appeal, and respondent number 82 in the IEBC appeal. Both of my clients are omitted from the AG's appeal. Thank you.
The Honorable Chief Justice, my ladies and my lords, my name is Wambulwa. I do appear for the Speaker of the Senate and the Senate, who are the 15th and 17th respondents in the Attorney General's petition, and 17th and 18th respondents in Morara Omoke's petition, and 8th respondent in the IEBC petition. I also hold brief for Mr. Kuyoni Josephat for the National Assembly and the Speaker of the National Assembly, who are 14th and 16th respondents
in the Attorney General's petition, 19th and 20th respondents in Mr. Moraro Moke's petition, and 7th respondent in the IEBC petition. Thank you.
Good morning, Your Ladyship, the Chief Justice, honorable judges. My name is Evans Ogada. I appear alongside Mr. Elisha Ongoya. We are on record for Justice Juma and Isaac Ogola. These two respondents appear at number 11 and number 12 of petition E16 of 2021. Thank you.
Good morning, Your Honors. My name is Isaac Alwochir, the 70th respondent in Morara Omoke's petition of appeal, 21st respondent in the Attorney General's appeal, and the 78th respondent in the IEBC appeal. Thank you.
With your kind permission, the Honorable Chief Justice, I'm Mr. Steve Ogola, here to pick a ruling on behalf of the proposed interested party, the Party of National Unity, in the AG's petition of appeal.
A very good morning, the Honorable Chief Justice, my lords, my ladies. My name is Odongo Brian, here to take a ruling for the proposed Amishi, Professor Rosalind Dixon, Professor David Landau, and Gautam Bhatia. Most obliged.
May it please you, my ladies, my lords. My name is Orlando Lembo. I appear together with Ms. Sally Omoto for Professor Charles Fombard and Dr. Adam Keabebe, who are proposed Amici. And I also hold brief for Professor Migai Akech, who is our proposed Amici.
Good morning, my ladies and my lords. I'm Barbara Kwanga. I appear for the proposed intended Amici, Professor Richard Albert and Professor Yaniv Rosnai, in a ruling in the AG's appeal.
Thank you. I think we have taken the quorum of all council and parties present. Directions, like I said, were given on filing the responses, which were filed. We also received 7 applications filed in the 3 petitions. We received 4 applications for parties seeking to join as amici curiae, filed in petition number 12 of 2021. We received 1 application for recusal filed by some members of the court, seeking for some members of the court to recuse themselves. in petition number 12 of 2021 by Mr. 𝙏𝙗𝙬𝙧. We also received one application for joinder as an interested party in petition number 12 by the Party of National Union or Unity. One application for consolidation of the petitions filed in petition number 11 of 2021 by Duncan Oburu Ojwanga. We deliberated on those applications as a court and considered the written submissions pursuant to Rule 4 and 31(1) of the Supreme Court rules, and the court will deliver our decision on those applications. On the application for recusal, I will request the Honorable Justice Philomena Mwilu, the Deputy Chief Justice and Vice President of the Court, to read the court's decision.
I'm most obliged, my Lord the Chief Justice. This is the application for the recusal of 2 of 3 judges of the court by Isaac Alocher, and this is the ruling of the court. Upon perusing the notice of motion application dated the 26th of October 2021 and filed on the 27th of October 2021 by Isaac Alocher, who is the 21st respondent in petition number 12/016 of 2021, seeking a recusal of Honorable Justices Mohamed Kadha Ibrahim, Smokin Wanjala, and Jokindong Susana from hearing and determining the petition of appeals arising from the judgment of the Court of Appeal delivered on the 20th of August 2021 in Civil Appeal number E291 of 2021 as consolidated with Civil Appeal number E292 of 2021, E293 of 2021, and E294 of 2021. Upon reading the grounds on the face of the application, the applicant's supporting affidavit sworn on the 26th of October 2021, the written submissions by the applicant dated the 26th of October 2021, the affidavits and submissions filed on the 27th of October 2021 respectively, and in particular the grounds in support of the application, mainly that A, the applicant launched with the Judicial Service Commission a petition on 6th of April 2016 for the removal of 6 judges on account of a breach of the Code of Conduct prescribed for judges and for gross misconduct, which petition is still pending, the Judicial Service Commission being non-responsive, leading the applicant to institute petition number 301 of 2016, to wit Isaac Aloch, Polo Alocher versus Hamed Isaac Hassan and 24 others, 2016 EKLR. B, the applicant's right to fair hearing under Article 50, Subarticle 1 of the Constitution is non-derogable and has to be balanced with the right for other parties in arriving at a just conclusion, which right cannot be superseded by the doctrine of necessity and the duty to sit as enunciated by the court in the case of Jasbir Singh Rai and 3 others. And in the case of Gladys Bosch-Sholay and the Judicial Service Commission, C, it is in the interest of the administration of justice that the court be objective and impartial, pursuant to Article 73 and Article 166(2)(c) of the Constitution, requiring each judge to observe the guiding principles of leadership and integrity, including objectivity and impartiality in decision-making. And considering the grounds of opposition dated the 1st of November 2021, filed by Paul Mwangi and Company advocates on behalf of the 20th respondent, the Building Bridges to a United Kenya, National Secretariat of the BBI Secretariat, and Raila Amolo Odinga, the 23rd respondent. The said respondents oppose the application on inter alia the following grounds. A, the application is an afterthought. It is ill-conceived and intended to convolute and delay the hearing and determination of the petition. B, the applicant has not demonstrated and or adduced any such evidence in support of the allegations on bias by any of the cited judges. C, the application is self-defeating for the reason that whereas the applicant cites 3 judges for recusal, he seeks the recusal of only 2 of them. D, the application offends the doctrine of the duty of a judge to sit. And further, considering the applicant's further submissions dated and filed on the 3rd of November 2021, in which he proposes that pursuant to Article 159, Subarticle 2C of the Constitution, the appeals instead be heard and determined by arbitration, conducted under the supervision of the court, the modalities of which can be dealt with during the case management conference. The court took the liberty to establish from the Judicial Service Commission the existence of the applicant's petition against the 3 judges. The Judicial Service Commission reports that it does not have evidence of ever having received any such petition, and there's nothing on its records. The 3 judges are similarly not aware of the existence of any such petition for their removal filed with the Judicial Service Commission by the applicant. In the above context, therefore, we make the following determination. A, the applicant has not adduced any evidence as to the nature and contents of his assent to which the applicant is aggrieved against each of the named judges. B, in the absence of the petition by the applicant against the judges before this court, either directly or through the Judicial Service Commission, the possibility of bias or impartiality we find is far-fetched and speculative. C, the applicant has not spelled out any specific allegation that is likely to impair the judges in dealing with the matter against the applicant, as the applicant indicates willingness to have either of the 3 judges he's accusing to be part of the bench and to have his petition resolved through alternative dispute resolution mechanism. D, the applicant having instituted his petition against the judges to the Judicial Service Commission, the same should be allowed to take its course, as the Judicial Service Commission is an independent constitutional body and operate separately from this court. Indeed, the applicant indicates that he took out proceedings in Isaac Aloch Polo Alocher versus Ahmed Isaac Hassan and 24 others, which proceedings we have not had sight of, and in any event are not subject of our determination. E. Article 25 of the Constitution protects the right to fair trial under Article 52 of the Constitution, which only applies to accused persons in criminal proceedings. This is distinguishable from fair hearing alluded to by the applicant under Article 51 of the Constitution. F. The doctrine of necessity and duty to sit, as set out in the case of 𝙏𝙗𝙖𝙬 and that of 𝙏𝙗𝙬𝙧, and appreciated by the applicant, necessitates that the present matter must be heard on its merits. This is owing to its public interest nature. We note that none of the other parties in this matter has supported the present application, and as rightly noted by the 20th to the 23rd respondents, this court under Article 163(7) of the Constitution and Section 3 of the Supreme Court Act is mandated to make authoritative findings and settle points of law such as those raised in the appeal before the court. G. The issue as to whether the necessity and duty to sit amounts to derogation of the right to fair hearing under Article 50, Subarticle 1 of the Constitution does not arise under these circumstances. H. The judges having been appointed in their present positions under the Constitution, including satisfying the provisions of Article 73(2)(b) and Article 166(2)(c) of the Constitution, their impartiality and integrity can only be negated following due process, which the petitioner alleges to have invoked, but which is inconclusive. 7. Having found the foregoing determination, we make the following orders. 1. The notice of motion application dated the 26th of October 2021 lacks in merit and is hereby disallowed. 2. There shall be no orders as to costs. Orders accordingly. Thank you, Chief Justice.
Thank you very much, the Honorable Deputy Chief Justice, for reading that ruling decision of the court. I will now go to the application for the joinder of an interested party, and I will request the Honorable the Justice Joaquin Dongo, Supreme Court Judge, to read the court's decision.
The Honorable Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, Council, this is the ruling of the court on the application by the Party of National Unity to be enjoined as interested party. I'll read it in summary. The full ruling will be available after this. Upon perusing the notice of motion, application dated 12th October by the applicant, Party of National Unity, and noting the applicant's filed submissions, also noting the opposition of the 7th, 8th, 9th, 13th, and 18th respondents, and considering all arguments and the law as set out in the Trusted Society of Human Rights Alliance and Mumo Matemo, and also in the case of Francis Muruatetu and others, we find that the applicant has not met the threshold for admission as an interested party, as it has failed to establish a personal interest or stake that is proximate enough to occasion any prejudice to it if not enjoined in these proceedings. We therefore find no merit in the application and we accordingly dismiss it. There shall be no order as to cost.
Thank you, Honorable Lady Justice Njoki Ndongo, for delivering that decision on behalf of the court. I will now request the Honorable Mr. Justice Renaura, Supreme Court Judge, to read the court's decision on the joinder of amici curiae.
Thank you very much, Chief Justice. The first ruling is by the first application is by Professors Rosalind Dixon, Professor David E. Lando, and Professor Gautam Bhatia. All the applicants seek to be admitted as amici curiae in petition number E016 of 2021. We have perused the affidavit in support, the submissions by the applicants, their reliance on the case of Trusted Society of Human Rights versus Mumo Matemo, and Raila Odinga and others versus IEBC. We have considered the grounds of position by the 20th and 23rd respondents. We have looked at the law in Rule 19 of the Supreme Court rules, the case of Trusted Society of Human Rights Alliance versus Mumo Matemo, and Francis Kariuki Muruatetu and another. We are not convinced by the arguments against the admission by the 20th and 23rd respondents. We see no evidence of bias, of lack of neutrality, and therefore, having considered the application against the rules and the law, we make the following orders. The motion dated 1st October 2021 and lodged on 4th October 2021 by the intended amici curiae is allowed, and this is important. The amici briefs attached to the application are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The second ruling is on the application of Professor Migai Akech to be admitted as amicus curiae. We have looked at Rule 3, 19, 31 and 50 of the rules, the practice directions of the court. We have considered the grounds in support of the application, the reliance on the case of Trusted Society of Human Rights Alliance versus Mumo Matemo. There is no opposition to the application. Having considered it, we are also of the view that Professor Migai Akech, in his brief, will be of valuable assistance to the court, and we have seen that he has demonstrated expertise in his field relevant to the proceedings before the court. In the circumstances, the application dated 20th October 2021 and lodged on 22nd October 2021 by the intended amicus curiae is allowed. The amicus brief attached to the application is deemed as filed, and the applicant shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The third application is by Professor Richard Albert and Professor Yaniv Rosnai. They have relied on the rules 3, 19, 31 and 50 of the rules. We have considered the grounds on the face of the application. We have read the amici briefs by both Professor Richard Albert and Yaniv Rosnai. Their reliance on Francis Kariuki Muruatetu and Trusted Society of Human Rights Alliance. We have looked at Rules 19 of the court rules and the two decisions I've just quoted above. We have seen that the applicants intend to address the court on the issue of constitutional amendments relevant, including questions touching on the basic structure, its scope, relevance, and applicability. In the circumstances, we have the view that the applicant's very detailed amici briefs shall be useful to the court and therefore we shall allow the application to be admitted as amici curiae. The amici briefs are deemed as filed, and the applicants shall not make oral submissions at the hearing of the petitions. Parties shall bear their own costs. The fourth and last application for admission as amici are by the by Professor Charles Fombad and Professor 𝙏𝙗𝙖𝙬𝙧. They have relied on Articles 1, 2, 3, 10, 48, 159, 160, 164, and 259 of the Constitution, and Rules 19, 1 and 2 of the Supreme Court rules, as well as the affidavit sworn by 𝙒𝙗𝙀 𝙀𝙀, advocate. We have looked at the amici briefs. They have detailed a number of questions for Professor Fombad. He has asked 3 questions that he wishes to address, and Professor 𝙏𝙗𝙬𝙧 has similarly raised 3 questions which he wishes to address. Having looked at the law, Rules 19 of our rules, the cases of Raila Odinga and others versus IEBC, Trusted Society of Human Rights versus Muma Matemu, we are of the view that the admission of the amici curiae will be useful in achieving our mandate to develop the law with the assistance of input from parties